Hello, my name is Rachel O'Kello and I'm a UK-based solicitor specialising in immigration, nationality and deportation law. And today is the first day in our 5-part video series where I'm going to be breaking down the elements of deportation law in the United Kingdom. So this is day number 1, and I'm going to start off at the beginning by saying, what is deportation proceedings? What does it mean if you're going to be deported? What will you expect if you are subject to removal directions or to a deportation order? And there's 2 types of deportation in the United Kingdom. So the first type of deportation is really more of an administrative removal. An administrative removal is for people who do not have the correct paperwork to be in the United Kingdom in the first place. So we really normally refer to such people as overstayers or illegal migrants, but it is typically somebody who entered the United Kingdom legally, but then their leave to remain expired and they either didn't apply to extend their leave to remain, or they applied and they were unsuccessful. Whatever the reason or whatever the situation, they now find themselves in a position where they do not have papers to be in the United Kingdom. They don't have permission to be here. And therefore, the position of the government is that such people should be removed. So that is one part of deportation, and we call that administrative removal, non-criminal deportation. The second type of deportation is when there is criminality involved, and that is where the principle around that type of deportation is that your presence in the United Kingdom is considered to not be conducive to the public good, and it is therefore in the public interest that you be removed from the United Kingdom. And this can be for anybody, whether they have leave to remain in the United Kingdom or whether they don't have leave to remain in the United Kingdom and they are an overstayer. So whether you have leave to remain, even indefinite leave to remain, or whether you have limited leave to remain, or whether you don't have any leave to remain at all, you can be subject to a deportation order. And the deportation order means that you are required to leave the United Kingdom. And if you do not leave the United Kingdom voluntarily, then you can be detained until such time as the government, the Home Office, is able to remove you forcibly from the United Kingdom. So those are the 2 types of deportation. One is where you've overstayed your leave to remain, and the other one is where your presence in the United Kingdom is considered to not be conducive to the public good, and it is in the public interest to deport you. And if you have a deportation order against you, then you cannot apply for leave to remain in the United Kingdom until that deportation order has been cancelled. And if the Home Office do forcibly remove you, you cannot apply to re-enter the United Kingdom as long as that deportation order is still live. So once the deportation order has been made, you must apply to cancel the deportation order before you can try to apply to stay in the United Kingdom, or before you can apply to re-enter the United Kingdom if you have already left. If, on the other hand, you have a administrative removal case against you, then it's very different, because there is nothing for you to seek to cancel. What you have to show in that case is that you have grounds to be in the United Kingdom. And it doesn't matter how late in the day it is, as long as you can show that you have grounds to be here, you can make that application. So we have helped people turn their case around and turn their situation around, even though they've been in the airport waiting room, waiting with hours for the plane to arrive to deport them, to remove them from the United Kingdom. And we have continued to fight that person's corner. We have called the judge up in the middle of the night, because there is a duty judge, and if you've got very good reason to call the judge, then you can take that chance and you can call the judge in the middle of the night and get an injunction against the removal of that person. So the person is not removed because you have shown that there are grounds for them to make a valid claim for leave to remain. So that person wouldn't have any criminal convictions or any criminality involved in their immigration history. That person has simply overstayed their visa, their leave to remain, and needs to show that they have grounds to make a valid application, which is likely to be successful. And it doesn't matter how late in the day it is, if you can make that application, then you can do so whether you are not detained, whether you are detained in immigration detention, whether you are in the airport waiting for the plane because the Home Office has come to remove you, or even whether you've actually been removed from the country. We have applied for somebody to be brought right back into the country because they were being unlawfully removed. And so even if you've been removed, you can apply to be brought back into the country. And we're seeing a lot of that with the Windrush generation as well, people who've either been removed from the country wrongly or being not allowed to re-enter the country wrongly. And we're seeing a lot around the Windrush generation of such people being able to stay in the United Kingdom or being allowed to re-enter. So that is what people call deportation, but it has no criminality involved. Okay. Now, on the other hand, we come back to criminal deportation. So if you have been in the United Kingdom and you are not British, if you have a criminal sentence, so you get a criminal conviction and you are sentenced to at least 12 months, it's not how long you spent in prison, it's that you are sentenced to at least 12 months in prison, then the Home Office has a duty, an automatic duty, to seek to give you a deportation order. They must automatically consider you for deportation. So one thing you can be sure of, if you have committed a criminal offence, got a conviction, and got a prison sentence of more than 12 months, at some point the Home Office are going to write to you and tell you that you are liable, automatically liable, they don't have any discretion in this, automatically liable to be considered for deportation. And you'll be given an opportunity to raise grounds as to why you shouldn't be deported. Equally, even if you didn't have a prison sentence of more than 12 months, but you are a repeat offender, so you are always offending and re-offending, then the Home Office can consider you for deportation as well, and they can consider giving you a deportation order. And the reason goes back to what I said at the beginning. The reason is that it is considered that your presence in the United Kingdom is not conducive to the public good, and it is in the public interest to remove you from the United Kingdom. So you have to understand the two different types of deportation proceedings and how it relates to you in your case if you think that you are threatened with being forcibly removed from the United Kingdom, and what you can do to prevent your removal. And it will depend whether you have criminality in your immigration history or whether there's no criminality in your immigration history. And the same goes for people who are trying to enter the United Kingdom as well. It will also depend, when you want to get entry clearance, on whether you have any criminality in your past, which will mean that you are a person who is not suitable to enter the United Kingdom. Equally, if you are applying for leave to remain because you have limited leave to remain and you are applying to extend your leave to remain and you have a criminal conviction, even if it's your first time, even if it's less than 12 months, then you may be refused further leave to remain because of the criminal conviction that you have. So it's very important to understand how it works, how criminality can affect your immigration status in the United Kingdom if you're not a British citizen. So I'm going to leave you with that today, just understanding what deportation is and what deportation proceedings are all about. And we are going to be tackling tomorrow the mindset that you need to have if you're going to put your best foot forward when confronted with criminal deportation proceedings. Okay, so that's it for today. And if you want to discuss your case privately, because this is just general information, then do contact us on 01213 894 895. Anywhere you are in the country, we can assist you, and you can book a free case assessment at clarityvisas.co.uk. We offer a free case assessment just to see, before you spend any money, whether you've actually got a case. Okay, so take care, and I will talk to you tomorrow. Bye-bye.